case of Takako Sakao against Ng Pek Yuen and Ano. Alright, for the fact of the case, Takako Sakao, a Japanese citizen, and Ng Pek Yuen were a business partner operating a restaurant in Malaysia. In 1992, both parties agreed and mutually understood that they will jointly purchase a shop house where the restaurant will be operating and own in equal share. Takako Sakao contribute Rm 194,610 towards the purchase price and other related expenses, relying on the agreement that she would be a co-owner. Contrary to the agreement, Ng Pek Yuen registered the property solely in her own name, excluding Takako Sakao from legal ownership. In 1996, Ng Pek Yuen sold the property to a company, which is the second respondent, for Rm 1.93 million without Takako Sakao consent. Takako Sakao lodged a caveat on the property and commenced legal action, claiming that Ng Pek Yuen held the property on trust for her due to their prior agreement and her financial contribution. The High Court and the Court of Appeal rejected her claim, holding that any trust was banned under Section 433B of the National Land Code because she was a foreigner. Takako Sakao appealed to the Federal Court, arguing that a constructive trust arose due to the breach of fiduciary duty and unconscionable conduct.
For the ruling of the case of Takako Sakao against Ng Pek Yuen and Ano, the first one is the classification of the trust. The court held that the relationship was a constructive, not a merely resulting trust, because the parties were business partners. They owed each other a fiduciary duty to act in utmost good faith. The first respondent committed equitable fraud by registering the property solely in her name despite their mutual understanding to own it equally. The second one is under the Section 43B of the National Land Code. The court ruled that Section 433B, which requires foreigner to obtain state approval to require land, does not apply to constructive trust. This is because constructive trust arises by the operation of law due to unconscionable conduct, rather than being created by the parties as an express trust or acquired through a standard disposal of land. The third one is adverse inference. The first respondent, which is Ng Pek Yuen, chose not to testify or give evidence. The court ruled that when a party with knowledge of the fact studiously refrains from giving evidence, the court must draw an adverse inference against them and presume the other party evidence to be true. The last one is piercing the corporate veil. The second respondent, which is the company that bought the property from Ng Pek Yuen, was found to be a sham and a facade used to evade legal obligation, as it was not a bona fide purchaser for value without notice. The trust remained enforceable against the company.
Sutra Harbour Golf and Country Club Berhad against Omega Brilliant Sindang Berhad and another. In this case, the issues involved of land law concerning tenancy and application of equitable principle. Although a tenancy agreement existed, the key question here is whether equity prevails to protect right arising from long-term occupation and the landowner assurance. This case involves Sutra Harbour Golf and Country Club Berhad as the owner of the land, and the first defendant is Profound Heritage as a developer who had built and continuously operate at cogeneration facility on the subject land since 1997. The second defendant is a director of Omega Brilliant and official of PH was involved in managing PH debt and handling matter related to the sale and purchase agreement SPA. Since 1997, PH carried out its operation on the land with the knowledge and consent of the plaintiff, who had assured or created a common expectation that PH would have a right to occupy and use the land. Relying on this assurance, PH invested substantial resources and constructed permanent facilities on the land. At a later stage, the SPA was executed to formalize PH's existing right over the land and was not intended as a genuine commercial sale. The tenancy agreement in 2002 was entered into primarily for tax and accounting purpose and did not affect PH's pre-existing right. In 2030, a subscription agreement brought in new investors, but they had no prior relationship with PH, and their involvement did not change PH's established right over the land. Then the plaintiff claimed ownership of the land and sought to challenge PH occupation, arguing that PH rights were not formally authorized. In response, the first and second defendant filed a counterclaim asserting that PH has a right to occupy and use the land based on the assurance and a common expectation given by plaintiff since 1997. They argued that the PH has invested substantial resources and built permanent facilities on the land relying on those assurances. The defendant maintained that the SPA and other agreements were made to formalize PH pre-existing rights rather than create a new ones, and that the tenancy and subscription agreement did not alter PH established right over the land. So, the court ruled that the plaintiff claim was dismissed. Meanwhile, the counterclaim of the first and second defendants was allowed. The court recognized the first defendant's right to occupy and own the subject land under the doctrine of proprietary estoppel. In addition, costs amounting to 50,000 were awarded in favor of the defendants. With regard to fiduciary duty, the court emphasized that directors must act in the best interest of the company and must not use their position for personal gain. In this case, the second defendant was involved in signing the sale and purchase agreement for a consideration of only 1,000 ringgit. The court held that this amounted to a clear breach of fiduciary duty. As such, equity will not protect or enforce transactions that are carried out in breach of fiduciary obligations. The defendants also relied on the doctrine of estoppel. However, this claim was rejected by the court. The court reiterated that estoppel requires a clear representation or promise, reliance by the claimant, and detriment if the promise is denied. In the present case, the tenancy had already expired, so the subject land was not part of the SPA, and estoppel cannot arise from an unlawful or wrongful act. Therefore, the requirements of estoppel were not satisfied. Furthermore, the court applied the clean hands doctrine and held that a party seeking equitable relief must act honestly and in good faith. The defendants were found to have conflicts of interest and had engaged in non-transparent dealings. Consequently, they were not entitled to equitable relief. The court also found that the transaction was manifestly unfair. The sale of the land for 1,000 ringgit was clearly unconscionable and oppressive. Equity does not support or uphold transactions that are one-sided or unjust. Finally, the court affirmed the principle that equity does not exist from. Equity cannot be used to legitimize fraudulent conduct or to override a breach of fiduciary duty. Accordingly, claims of estoppel or ownership could not prevail in the face of such wrongdoing.
Lastly, I will present a case about injunction under equitable remedies, which is called Daya Maju Sdn Bhd versus Kerajaan Malaysia and another. The plaintiff in this case is Daya Maju LTAT Sdn Bhd. The defendant in this case, we have two defendants. The first is the government Malaysia and the second one is the Minister of Transport. The government awarded the plaintiff the Klang Valley Double Tracking Phase 2, we call KVDT2 project via through the first letter of acceptance, we call SST1, on 4 April 2018. This project value 5.58 billion and the period time is the 7 years. On 19 October 2018, the government suddenly cancelled the project on the ground of public interest, security and national interest. But the plaintiff objected the termination and the negotiation was held between the parties. On the 19th August 2019, settlement agreement was signed. The government agreed to reappoint the plaintiff and reduce the project cost to 4.475 billion. The plaintiff agreed to release all claims related to the termination of SST1. On the same day, the government issued a second letter of acceptance called SST2 to the plaintiff. In SST2, state that the contract was legally binding, although the former contract had not yet been signed. The plaintiff commenced work and several payment certificates have been issued, but some payments were still outstanding. On 28 August of 2020, the Minister of Transport suddenly announced through the Ministerial that KVDT2 project will be reopened for the new tender. The announcement was made without any formal termination letter for SST2. The plaintiff argued that the announcement showed the government's intention to invalidly terminate the contract. The plaintiff claimed that the minister's actions constitute an abuse of public authority and interference with a valid contract. The plaintiff filed a civil action and sought an interim injunction to prevent the government and the minister from cancelling SST2 and opening the new tender for the project. The application for this injunction was made under Order 29 Rules of Court 2020. The High Court dismissed the plaintiff's application for injunction. The court ruled that no injunction could be granted against the Malaysian government, whether an ad interim injunction, an interlocutory injunction, or a perpetual injunction. Section 29 of the Government Proceeding Act 1956 served as a legal bar to the court for issuing an injunction against the government. Section 54, Subsection D of the Specific Relief Act 1950 also prevents the granting of an injunction that may interfere with the public duties of any government department. Although the case involved a contract, the effect would still be to restrain the government actions and decisions, so the injunction was not allowed. The court emphasized that the minister being sued was acting in an official capacity, hence the legal protections against the government still apply. If there was a breach of contract by the government, the appropriate remedy for the plaintiff was a declaration of rights or a claim for damages, but not an injunction. Therefore, the court ruled that it did not have jurisdiction to grant injunctive relief as sought by the plaintiff. So, the plaintiff application was dismissed with cost of 10,000 ringgit to the defendant.
I'm going to talk about significance and impact in Daya Maju Eltad Sendirian Berhad versus Kerajaan Malaysia in another case that lies in its affirmation that the government is bound by the rule of law when dealing with contractual and property rights. The court held that executive power cannot be exercised arbitrarily to terminate or interfere with lawful development agreements on the mere ground of public interest. Its impact is that it strengthens Article 13 of the Federal Constitution, extends protection to contractual and development rights, and it reinforces judicial review over executive action. The case enhanced legal certainty and investor confidence by making clear that government interference must be authorized by law and accompanied by compensation.